Breaking news. Welcome to today's headlines. Nnamdi Kanu's lawyers write Attorney General Malami asked Nigerian government to obey UN ruling to free IPOB leader unconditionally. Nnamdi Kanu's lawyers write Attorney General Malami asked Nigerian government to obey UN ruling to free IPOB leader unconditionally. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. The legal team of Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu has asked the Nigerian government to release him unconditionally in line with the recommendations of the United Nations. The working group had declared the arrest of Kanu as unlawful and an infringement on his international human rights. It also called for the immediate release of the IPOB leader and compensation by the Nigerian and Kenyan government for the way he was treated. The Working Group on Arbitrary Detention under the United Nations Commission in Human Rights UNCHR disclosed this in a statement published on its website. The group comprised scholars and experts who specialized in human rights issues and related laws. In a letter addressed to the Minister of Justice, Attorney General of the Federation, Abubakar Malami, and the Minister of Foreign Affairs, Geoffrey Onyema, the lawyers demanded the release of the IPOB leader. Those who signed the letter are Chukwuma Machuku and Aloy Ejimako. They reminded Malami of the need to accord Kanu an enforceable right to compensation and other reparations for his continued unlawful detention. The letter reads partly, "As you must have noted, the opinion demanded the government of the Federal Republic of Nigeria to immediately and unconditionally release our client, Mazi Nnamdi Kanu, and accord him an enforceable right to compensation and other reparations for his continued unlawful detention." The working group requests the source and the government to provide the above-mentioned information within 6 months of the date of transmission of the present opinion. However, the working group reserves the right to take its own action in follow-up to the opinion if new concerns in relation to the case are brought to its attention. Such action would enable the working group to inform the Human Rights Council of progress made in implementing its recommendations as well as any failure to take action. Your Excellency, we are sending this demand letter to you because we believe that the subject matter falls under the jurisdiction of the Foreign Relations Ministry of Nigeria, as it is the duty of the ministry to, among other things, ensure that Nigeria complies with our obligations under international law. Thus, in your considerations of the subject matter of this letter, we respectfully invite you to be guided by the following. The working group, which is an integral part of the United Nations Human Rights Council, is a quasi-judicial body that has the legal mandate of the United Nations to adjudicate human rights petitions brought against member nations of the United Nations. The opinion of the working group is legally binding on Nigeria because it is based primarily on universal human rights standards set by Article 9, one of the International Covenant on Civil and Political Rights, 1966, the Universal Declaration of Human Rights, the Universal Declaration of Human Rights, 1948, the body of principles for the protection of all persons under any form of detention or imprisonment, 1988, the Declaration on the Protection of All Persons from Enforced Disappearance, 1992, the Principles on the Effective Prevention and Investigation of Extra-Legal, Arbitrary and Summary Executions, 1989, all to which Nigeria is a signatory. Some of the above human rights instruments were mentioned in the opinion as having guided the working group in reaching this decision. To be sure, ratification is a means by which a nation renders itself subject to international laws and treaties, and by virtue of Section 12 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and a plethora of decisions by the Supreme Court of Nigeria, see Abacha v. Faweyimi, Abacha vs. Faweyimi 2006, NWLR Part 660, P228. Ratification makes Nigeria subject to and bound by whatever treaties, principles, protocols, etc. that it ratified and domesticated. To my dear listeners, now we've come to the end of our today's news.